Hello, everybody.
This is in the District Court of Greenwood County, Kansas, case entitled State of Kansas versus Stephen Warren Hoffman. It's case number 2024 CR 87. Jill Gillette appears as Greenwood County Attorney. Richard Paw as Defense Counsel. Defendant Hoffman appearing from the Greenwood County Jail's Zoom location. This matter comes before the court at this time for arraignment. The court noting that the matter came before apparently the magistrate court on March the 29th. At that time, the parties waived preliminary hearing. Defendant was bound over for arraignment today. Mr. Paw, does your client desire the charging document to be read to him?
No, Your Honor. We would acknowledge copy of the receipt, copy of the complaint, acknowledge its receipt, waive its formal reading, and pursuant to plea negotiations, Mr. Hoffman is going to plead guilty to count 2, identity theft. And in exchange for that successful plea, counts 1, 3, 4, 5, and 6 will be dismissed.
The intention is that that's going to be done today?
Correct?
Ms. Gillette?
Yes, he's pleading to the identity theft, Your Honor.
All right, Mr. Hoffman, is it indeed your intention to enter a plea of guilty and accept conviction for the identity theft count 2?
Yes, sir.
Obviously in return for the state's dismissal of all the other counts, correct?
Yes, sir.
Okay. I've got a number of questions I need to ask you regarding the taking of the plea. If there's any question asked of you that you do not fully understand, I will give you the opportunity to confer privately again with your lawyer, Mr. Paw. Just let the court know at any point if you need that time to get further advice, okay?
Yes, sir.
State your full legal name for the record.
Stephen Warren Hoffman,
How old are you right now?
37.
What's the highest level of formal education that you've attained?
Some college.
Do you believe you're going to have difficulty understanding any of the legal concepts
No,
that
sir.
we're going to be discussing in court?
No.
Have you ever been adjudged to be mentally ill?
No.
Are you currently under the influence of alcohol or any drug?
No, sir.
Are you currently taking any type of prescription medication?
No.
Are you supposed to be taking mental health meds that you are not currently getting?
No.
So as you sit today, do you believe your mind is clear, Mr. Hoffman, and that you
Yes,
have a
sir.
full understanding of what's going on here in court?
Yes.
Did you receive a copy of this original charging document in the case?
Yes, I believe so.
Do you understand the nature of the charge of identity theft as charged in count 2?
Yes.
You understand that when you enter a plea of guilty, you are admitting that act of identity theft as charged in count 2 of your information.
Yes, sir.
You also understand that when you enter a plea of guilty, you're giving up any legal defenses that you might have had to that charge.
Yes.
Are you aware that in a trial, the state must present evidence against you in open court, that any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses with the assistance of your lawyer, Mr. Paw, and that at such a trial, you could present evidence on your own behalf and you could subpoena your own witnesses to court? You understand that?
Yes, sir.
You also understand that at such a trial, you personally would have a privilege against self-incrimination, which means that if you wanted to testify in your case, you could at your choice, but no one could force you or compel you to testify against yourself if you didn't want to. You understand that, Mr. Hoffman?
Yes, sir.
You understand that when you enter a plea of guilty, you give up these valuable trial rights that the court has described.
Yes, I do.
You also understand that you have a right to a trial by jury, and that before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt.
Yes.
Understand that when you enter a plea of guilty, you give up your right to a trial by jury and the requirement that you be found guilty beyond a reasonable doubt.
Yes, sir. I understand.
You understand that you have a right to appeal a guilty verdict if you have a trial.
Yes, sir.
Mr. Hoffman, do you further understand that you may appeal your sentence after entering a plea of guilty, but generally you may not appeal your judgment of conviction after you enter such a plea?
I understand.
Now, are you aware of the possible penalties that could be imposed as a result of this guilty plea that you are attempting to make?
Yes, sir, I am.
Let's go over those. Identity theft is a severity level 8 non-person felony. In the most favorable criminal history category under the Kansas Sentencing Guidelines Act non-drug grid, you could receive as little as a 7-month prison sentence. However, in the worst criminal history category of A, you could receive as much as a 23-month sentence. So the sentencing range is 7 to 23 months in prison, depending on your criminal history. Mr. Hoffman, as you sit today, we do not know with certainty what your criminal history is. You, better than anyone else participating, should know what your own criminal record looks like. But that will be researched by the Court Services Department, and based on the outcome of that research, as of the date of sentencing, that determines where you fall along the level 8 line, and then you'll be sentenced accordingly. You understand that?
Yes, sir.
Mr. Hoffman, you also understand that if you have 2 or more person felonies on your record at time of sentencing, you would be presumptive prison here.
Yes.
You also understand that you could receive up to a $100,000 fine for this offense?
Yes, sir.
In addition to any fine, are you aware that you could be assessed and be required to pay court costs, certain fees, including reimbursement of legal fees and expenses, and restitution to victims, if any are owed, as part of your sentencing orders?
Yes.
You also understand that as a direct consequence of this plea, you will be sentenced to an extended period of reporting probation, reporting parole, or post-release supervision as deemed appropriate by the court at time of sentencing.
Yes.
Mr. Hoffman, you understand that both probation and post-release supervision periods generally start at 12 months in duration, but can run up to 60 months under some circumstances.
Yes, sir.
Mr. Hoffman, I also want to make sure you understand that the Kansas Sentencing Guidelines Act is much more than the grid that I referred to earlier. It's an entire book of sentencing rules and laws. Among these rules and laws are special sentencing rules. You understand that if any special sentencing rules apply to you in your situation, it could affect your eligibility for probation or otherwise affect your sentence.
Yes.
Did you have an ample opportunity to discuss legal matters like that with your attorney, Richard PAW, before proceeding here today?
Yes, sir.
You want any more time with him privately now before we go further?
No, sir.
Are you satisfied with the services and advice given to you by your lawyer?
I am.
Now, this guilty plea that you're attempting to make, Mr. Hoffman, has it been based upon any threat or promises as to what this court will do in regards to sentencing or any other type of threat or promise?
No, sir.
Is there anything else that you thought was part of this plea deal that hasn't been made part of the record already?
No, sir.
All right, Mr. Hoffman, do you understand that if there are any plea agreements between your counsel and the county attorney's office regarding sentencing recommendations, that this court is not bound by any agreements made? The court may and shall consider them as recommendations, but is not bound by them. Do you understand that?
Yes.
So let me ask you formally, how do you plead to this charge in count 2, identity theft, a level 8 non-person felony?
Guilty.
According to the state's charging document, this took place March 22 of 2024. Is that when it happened?
Yes, sir.
It happened somewhere in Greenwood County. Where was it?
Eureka.
Okay. And what did you do that would constitute identity theft?
I was driving. I just got into town. It was late at night. I got pulled over. When the officer asked me for my information, I gave him another person's information.
Okay, well, who was the other person?
The name was David Samples.
Did you do that to avoid detection of warrants in your name?
Yes. Yes, it did.
All right. And you thought that would benefit you if you did that. Is that correct?
At the time, I thought it might work or help. Yes.
All right. So do you now freely, knowingly, and voluntarily enter a plea of guilty and accept conviction for identity theft, a level 8 non-person felony?
Yes.
Ms. Gillette, do you know of any legal reason why the court should not accept this defendant's plea?
No, Your Honor.
Mr. PAW, are you aware of any such legal reason?
No, Your Honor.
All right. Mr. Hoffman, are you aware of a legal reason or any other good reason why the court shouldn't accept your guilty plea here this morning?
No, sir.
Court will accept the guilty plea made by the defendant and finds that that plea is made voluntarily. he has an understanding of the nature of his charge and the consequences of his plea, and a factual basis for the plea does exist. Court finds him guilty, and the judge is him therefore convicted of identity theft, a level 8 non-person felony. All other charges of the information are dismissed pursuant to plea agreement. Court will set a sentencing date and order a pre-sentence report be completed to accurately determine this defendant's criminal history. I'd like to go ahead and sentence you today, Mr. Hoffman, but I can't do that. There needs to be an investigation process that takes about 2 months. So I'm going to set the sentencing date out sometime in July.
Yeah, Judge, we would like it as quick as possible, Your Honor.
Yes, sir, please. Really appreciate it.
Well, I have limited dates with Ms. Gillette, so Thursday, July the 18th.
Anytime, Judge.
I'm almost reconsidering that date. Why are you in custody, Mr. Hoffman?
Why am I in custody?
Is it this case, or do you have other holds?
It's this case. I have a hold from Minnesota, an old probation violation. It's like 3 or 4 years old, which is why identity theft happened. Yeah. And my bond was very, very high as well. That's also a thing.
All right, I may be setting this case up for continuance, but I think I'm going to go ahead and set a date on Thursday, June the 20th. That only gives court services about 5 weeks, maybe 6. That's.
I really appreciate it.
But I think I would rather continue the case on June 20th if we can't get the report done, then set it out 10 weeks, which I'd have to do with a July date, because he's going to be sitting in custody the entire time.
What time on June 20th, Your Honor?
9:30 a.m.
That would be great.
Right, I'm going to set your sentencing in this case, at least tentatively, and I hope you understand that court services works very, very hard to get these reports done. They have to do a research of your criminal history, and apparently some of it's in Minnesota. So,
yes, sir. While I have you here, and we were talking about me being in custody, is there a way we get my bond lowered to something a little bit more attainable? Because my family doesn't have that kind of money. I've never had a bond this high either.
well, but Mr. Hoffman, if you've got a hold out of Minnesota, you're not getting out.
Well, that's a that's a thing. I've been arrested on this charge before from Minnesota, and they have released me with the warrant, and they have also dropped the warrant completely, and then it showed back up later. So it's like it's a 50-50 chance that it depends on how they would want to deal with it. But
well, if you're eligible for a bond in this case with no other holds, then we'll take it up then.
Oh, okay.
Your attorney can apply to the court for a hearing, but it doesn't sound like Minnesota wants to release their hold.
All right.
They may have represented at one time they were going to do that, but apparently they still want you. So you're not being held solely because of this case at this juncture. Okay, so the Hoffman sentencing has been set on an expedited basis for Thursday, June the 20th at 9:30 a.m. I'm contemplating that be done by Zoom, similarly to today. Thursday, June 20th, 9:30 a.m. for sentencing.
Thank you.
And that's about the quickest sentencing I've set for years.
I really do appreciate it. Thank you.
I just hope court services can get it done. If they can't, then they'll let me know and we'll have to continue it. But we'll have a hearing either way, Thursday, June 20th, 9:30 a.m. contemplated to be a sentencing on this felony case. Mr. Paul, is there anything else we need to address from your perspective currently?
No, Your Honor. Thank you.
Ms. Gillette, anything further at this time?
I can't think of anything else, Judge.
Very well. Then if there's nothing further at this time, the Hoffman matter will be in recess and this meeting may be ended for all at this time. This is in the District Court of Greenwood County, Kansas. Case entitled State of Kansas versus Stephen Warren Hoffman. It's case number 2024 CR 87. Jill Gillette appears as Greenwood County Attorney, Richard Paw as defense counsel. Defendant Hoffman appearing from the Greenwood County Jail. Mr. Hoffman now faces sentencing for identity theft pursuant to a guilty plea that he entered on May the 9th of 2024. Court at that time accepted that plea, found him convicted, and ordered a pre-sentence report, the sentencing set for today. Court has received a pre-sentence investigation report compiled by Jessica Morgan, pre-sentence investigator, who is present on this meeting with us. I trust each attorney's received a copy of this report, and I'll ask the state's attorney first. Is there any objection to the criminal history which is stated in this report?
No objection from the state, Your Honor.
Any objection by the defense, Mr. Paul?
No, Your Honor.
The court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score E, and the court will proceed further accordingly. Ms. Gillette, do you know of any legal reason why sentence should not be pronounced in the Hoffman case here this morning?
I do not, Your Honor.
Mr. Paul, are you aware of any such legal reason?
No, Your Honor.
Mr. Hoffman, are you aware of a legal reason or any other good reason why the court shouldn't proceed further with your sentencing today?
No, Your Honor.
Court proceed further then. Counsel, I'm not aware that there's been a motion for a departure sentence or any other type of sentencing related motion to take up. Does the state have any such motions to pursue?
We do not, Your Honor.
Does the defense, Mr. Paul?
No, Your Honor.
Are there any victims or members of a victim's family present who desire to address the court in relation to the Hoffman sentencing? The court finds no such persons on this meeting, and therefore the court at this time will ask for recommendations from counsel regarding an appropriate sentence for Mr. Hoffman, beginning with Jill Gillette on behalf of the state.
Your Honor, this is a case that is presumptive probation, but the defendant has holds for other jurisdictions. And so he has remained in custody for the other jurisdiction hold. This crime was committed while on felony probation for Minnesota case 55 CR 20 1447 and felony bond in SD 51 CR 120 002171 and CO 20 CR 52. So those holds are what's keeping him in custody. So he does have 91 days of jail credit. His primary offense is for count 2, identity theft. And it has a standard box of 14 months underlying with up to 20% good time credit. We'll be recommending the standard box and post-release supervision duration of 12 months if he serves any of his underlying with a probation term of 18 months. He is not eligible for any kind of treatment because of residency. It is anticipated he will have to clear up his other warrants, and he will need to keep in contact with probation as to when he is released from anywhere here. He does have a residence in Texas, so there will need to be a transfer to Texas for his supervision. He scored out for community corrections, and he scored high on his LSCMI as well as having special rules apply. There is a recommendation for a drug and alcohol evaluation to follow up on all of the recommendations, the other standard conditions of probation. It does say that his DNA is on file. And so he may already have met that requirement by providing his DNA. If for any reason we do not have a copy of it, we would ask that he submit DNA, and if a fee is added, that it be added. Other costs in this matter are court costs, KBI, lab fees. There is DNA database fee. I don't know why page 1 or the other page says on file when it's asking for the fee, and I don't see him as having done it in Kansas. Community corrections fee and correctional supervision fee, booking and fingerprint fee. We would ask for at least the bids application fee and the court to make findings pursuant to Robinson. If he is put onto community corrections and goes back to being employed, he would have wherewithal to pay back some, if not all, of his attorney's fees. This is a crime while committed on felony bond and while on probation, parole, or conditional release. On page, well, it's the first page of the criminal history worksheet, it's face sheet. He was on probation in Olmsted, Minnesota, and he would be to be consecutive to that unless there's manifest injustice. So we'd ask that the court make sure that that is consecutive, and those are the recommendations of the state.
Very well. Mr. Paw, your recommendations regarding an appropriate sentence?
Yes, Your Honor, thank you. We would ask that you sentence him as the underlying to the standard box of 14 months, grant him probation, make that consecutive to any and all cases that he has at this moment, put him on probation for 18 months. Mr. Hoffman, after he clears up whatever he's going to on his other cases, is going to be living with his sister in Winfield in Cowley County. So we would ask that the probation be authorized to be transferred to Cowley County. Judge, I think I have approximately $800 in fees at this moment. Mr. Hoffman has had 91 days consecutive in custody at this point, as evidenced by his jail credits. We would ask that the attorney's fees be waived, but we will leave it to your discretion on the bid's application fee, Judge, and that's all I have.
Mr. Paw, I looked at the criminal record of this defendant, obviously all contemplated by this criminal history score of E, but noting he's a serial thief. Wherever he goes, he steals. Why shouldn't he just be required to do the rest of his time in prison? There's a special rule which allows it without departure. The court, just as a matter of discretion, can order a prison sentence for Mr. Hoffman. Why should he be put back into a Kansas community when he has done nothing, according to his criminal history, but steal for wherever he's been?
Well, Judge, when speaking with Mr. Hoffman, he's had 91 days to reflect on whether he's going to prison or not. That's why he is going to not move back to Texas to live with his sister in Winfield. I believe she is working and has found employment opportunities for him there in Cowley County. So that's what my answer would be to the court.
Well, I'll just notice here, Mr. Paw, that he has had convictions in Texas, Wisconsin, and Minnesota, and you would have this court believe that he hasn't done significant jail time on any of those charges in any of those states. So in other words,
sure
the argument that he's now spent some time in jail in Kansas and he's had time to reflect now, and now he gets it for the first time. It's just hard for this court to swallow, given his extensive criminal history involving theft charges.
Judge, I don't know how much time he has spent in those other jurisdictions, but I would rely on my previous statements. I mean, the Greenwood County Jail is no picnic, Judge, and so that's why I would say what I just did.
Can I speak?
Just a moment, Mr. Hoffman. I'll address you in a moment.
Yes, sir.
All right, at this time, the court won't address the defendant personally, and I'll ask Mr. Hoffman if he has any statements he wishes to make himself in mitigation of punishment or anything further that he would like to present to the court.
I understand that my criminal history isn't the best. Those other
Horrible. It's not the best. It's horrible.
Yes, sir.
Okay.
I have all these things happened when my grandmother passed away. I went crazy, and it was regrettable. It was horrible. I had been high since the day she died. I have been on drugs since the day she died. I haven't taken a break once. This arrest, this 90 days is the longest time that I had been sober since her death. And I have reflected, and I am sorry for the crimes I committed. And if you just give me a chance to prove that, I won't let you down. I have a family. I have a support system. I have a life. I can be a productive member of society. And I apologize for the way it looks, but I'm a good person. I'm a good man. I have morals. I respect the law. I just not making excuses, but that's just things have been very different for me these last couple of years. And I went on a binge and I just couldn't stop. And I apologize for that.
Mr. Hoffman, what about all of the history of criminal offenses that go all the way back to 2005?
Again, I was high. I was high. It was
So being high is a justification for stealing from others?
it is not justification. There is no justification for that, sir. Wrong decision making, but I am a good man. Sober Stephen Hoffman is a good man, a dependable man.
Your criminal history would seem to suggest otherwise, Mr. Hoffman. Good men don't commit numerous thefts, evade arrest, burglarize, possess the dangerous street drug of methamphetamine, resisting an officer, financial fraud. Those are all very deliberate crimes. I appreciate your statement to the court, Mr. Hoffman.
Shouldn't be.
Court hereby establishes count 2 as the base sentence in this case for the offense of identity theft. A severity level 8, non-drug, non-person felony, for which the defendant has a criminal history score of E, thus placing him in grid box 8E. Court hereby sentences the defendant to a term of 14 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. The court has considered but declines to impose a fine in this particular case. Court does find that in grid box 8E, this defendant would be presumptive probation under Kansas law, but I'll also note that special rules apply in this case. This crime was committed while on felony probation, apparently out of Minnesota, and this crime was committed while he was on felony bond also. So obviously, in the view of the court, aggravating circumstances here. So the real question before this court is, Mr. Hoffman, today is whether you're even amenable to probation. Number one, you have such a history of serial criminal conduct, it's difficult for this court to believe that 91 days in the Greenwood County Jail, which has been told to the court is no picnic, is suddenly going to modify your behavior where you're going to start conforming to rules. It's just hard for me to accept. It's just difficult to imagine you out in the community and being successful given your track record. What's dramatically different now, I don't know. You talk a good game today, Mr. Hoffman. You act like that you're all straightened out and that you somehow have reached an epiphany now and you now intend to comply with rules, but you haven't done that in the past. But regardless of the minor hand slaps that you may have received in Texas and Minnesota and wherever else you've committed crimes, you committed a crime in Kansas. And I have to worry about whether you're going to comply with Kansas rules and to protect the people of this state. I'm having difficulty understanding why this court should give you another chance. Also, the issue of amenability here. Mr. Hoffman, you have holds from other jurisdictions, do you not?
Yes, sir. There's
So how are you going to report on probation if you continue to be locked up either here or elsewhere because of unsettled criminal action business in these other states?
Well, these I have back time on these other warrants, and is what I've been informed is that they're not coming. My mom has spoken to somebody, my sister's talked to my lawyer. It's too far away. At this point, as of confirmation on the warrant, whenever I was last arrested, I have too much back time. They've already closed out that probation. They're not going to come. In fact, one of the warrants was I was arrested on I don't know, last year or the year before or something like that, and they're like, yeah, we want him, we're going to get him. And then they held me for 24 hours, and then they actually changed this warrant to in-state because I'm not a resident. They know they're never going to see me again. I don't go up there. It's not if I get probation here, I will be released in be with my sister, my niece, and my nephew in Winfield, and I could report immediately.
I wouldn't be so sure on any of that, Mr. Hoffman, but nevertheless, court will enter an order at this time following the statutory presumption established by the legislature of the state of Kansas regarding this defendant being presumptive probation. The court will grant the defendant at this point 18 months probation to be supervised by community corrections. Community corrections supervision is deemed to be appropriate by the court because of the very high risk score on the LSCMI and because special rule applications do apply. Conditions of that probation will be to report to an officer as directed. Mr. Hoffman must observe all laws. He must abide by the recommendations of an alcohol and drug evaluation to be performed within 45 days of his release from incarceration. And that evaluation must be approved by the supervising officer. He shall not possess or consume alcohol or illegal drugs while on probation. At his ISO's request and at his own expense, he shall submit to random breath, blood, and urinalysis testing, gain and maintain employment throughout his probationary term, notify his supervising agency of any change in employment, residence, telephone number, or email address within 24 hours of any such change occurring. I'll note that his DNA apparently is already on file. If the Kansas $200 fee has not been paid, the court assesses it to the defendant. He shall abide by any curfew or travel restrictions associated with the community corrections program and attend, participate in, and successfully complete a theft or integrity program, all as approved by his supervising officer. He shall be assessed the DNA fee as stated before, felony docket fee, felony probation fee, community corrections fee, $45 booking and fingerprint fee. Bids assessments are waived. Court at this time doesn't have enough information regarding his future financial circumstances to be able to assess bids amounts. Those will be waived by the court at this time, though reasonable. Furthermore, the court will require an in-person reporting to community corrections within 60 days of today's date. If because of his unavailability for whatever reason, most likely because of continued incarceration due to holds or sentencing or incarceration orders from other courts, the court does direct the community corrections officer to seek a warrant seeking review. The question has a definite concern here over his amenability to Kansas probation, given his criminal involvement in many different states at the same time. If he's not reporting here in Kansas, he's not really on Kansas probation here. And the court wants to review this sentence and take possible action upon this sentence if he can't report in person to a community corrections officer here in Kansas within 60 days of today's date. This is certainly a case where the court would have imposed the maximum jail sentence as a condition of probation that Kansas allows, which is 60 days. I will note he's entitled to 91 days of accrued jail time credit. That exceeds the 60 days. Therefore, the court will order him released on community corrections in this case at this time, crediting that 91 days. Some point in the future, Mr. Hoffman, you may have the right to seek expungement of this offense. Certain statutory limitations do apply. If you have any question about your right to someday seek expungement, you can address those questions to a lawyer and I'm sure get your questions answered. Under certain limited circumstances, a convicted criminal defendant in Kansas has the right to appeal their conviction to an appellate court having jurisdiction. And if they are unable to pay the cost of an appeal, the defendant may request the court to appoint a lawyer to represent them on appeal and that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 223608C, Mr. Hoffman, you, the defendant, have 14 days after this judgment in court to file any notice of appeal with the clerk of the District Court of Greenwood County, Kansas. You do have the right to appeal this sentence. If the court has ruled adversely to you at this hearing, I will remind you that there is prohibitions against a convicted felon possessing a firearm, and that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. The court's probation order contemplates that he will establish and maintain Kansas residency, as has been represented here. Transfer of any probation is a matter to be handled by the Community Corrections Department. based on good cause for doing so. Mr. Hoffman, I think you've noted that this court has severe reservations about placing you on probation in this case. It had the option to send you to prison. You have another opportunity, theoretically, to be out in the Kansas community and being successful on a community corrections program. If you have to come back before this court on review of that sentence for any reason, I think you probably already know what's likely to happen.
Yes, sir, I understand. And thank you for the opportunity. I appreciate it.
Either do things right or you're going to do time.
Yes, sir.
Further, this court is going to order this defendant, Mr. Hoffman, to immediately contact the Community Corrections Department in Butler County as soon as he is released from incarceration. Mr. Hoffman, I want to make sure that you understand that it's not their responsibility to chase you and track you down.
Yes.
It is your responsibility to contact them, the Butler County Community Corrections Office, as soon as you get out.
I understood.
All right. Ms. Gillette, is there anything further we need to address regarding Mr. Hoffman at this time?
I can't think of anything else, Your Honor. Thank you.
Mr. Paul, anything further currently?
No, Your Honor, thank you.
Mr. Clausing, the ISO from Community Corrections on this meeting, do you need any clarification from the court or anything else?
No, Your Honor, I was just going to say I am in Greenwood right now, and as soon as I'm done here and I've got a few more clients to meet, I'll go down to the jail and meet with him personally. And if he gets out of jail before then, make sure you find me in the courthouse today if I don't see you in the jail.
Yes, sir.
Excellent, Mr. Clausing. I appreciate your endeavors in that regard. If there's nothing further, then the Stephen Hoffman matter will currently be in recess, and this meeting may be ended for all at this time.
Be safe, be well, sleep sweet, and much love.